Great, thank you, Heather. Hi, good afternoon, everyone. I am so happy to welcome all of you and thank everyone for coming together this afternoon for our critically important discussion around Native American Heritage Month. November is an important time to recognize and celebrate the countless ways Native Americans have influenced our culture, defined our history, and contributed to our groundbreaking changes for equity and equality. And as you will all hear today, this is an incredibly important time for us as the focus on ICWA, right, this week as we sit here today in the Supreme Court, a case that could potentially undo all the progress that we have made to ensure Indigenous peoples remain connected to their rich culture and community, and that is incredibly important to us here in New York. But before we move on and hear about that, I do want to take a moment for us just to acknowledge the 9 tribal nations that we celebrate and honor here in New York: the Seneca, the Cayuga, Oneida, Onondaga, Mohawk, Tuscarora, Unkachung, and the Shinnecock Nation. These nations, all within our corners of New York State, have been here long before the actual legal founding of our state, and their unique customs and language have survived centuries, right, of outside oppression and influence. And part of our journey, right, as white people, is really understanding the harm that we have done over many years, and we are certainly not alone. Many other states and nations have contributed to that harm. We know that for a long time, Native American children were forcibly removed, right, from their homes and tribal communities, stripped of their culture and language, and indoctrinated with, right, our culture of white supremacy. And it's also highlighting the central importance of ICWA, right, to cease those practices and to make sure that Native children are kept connected to their tight-knit families, communities, and culture. And while we know we cannot change history, right, we can change the future. And we want to make sure that our practice here in New York remains strong in supporting the culture and honoring the traditions and the rightful ownership of our tribal communities. We stand in strong support of the Indian Child Welfare Act. We've known it to be the gold standard in child welfare, and we cannot stress how important it is to keep our Native children connected to their culture and communities. I had the privilege earlier this year, with Heather's help, in visiting the Tonawanda Indian Community House and sitting with tribal leaders and community members. And it was just one of the most powerful experiences of my decade of time here in the executive office. So we're going to do whatever we can as New York State to stand and support our tribal communities. So I could go on, but we've got a great panel of presenters. We are going to be honored to hear today from Chief Judge of our St. Regis Mohawk Nation, Garrow, who's going to explain from her unique perspective, right, of what the importance of this moment is, the enormity of what's at stake as we sit here today in the Supreme Court. So I'm pleased to see so many of our staff taking the time to learn, and for all of us to own the part we play in making sure that we are holding true to keeping Native American children and to doing everything we can to repair the harms that we have done as a state and as a nation. So thank you all. And I will happily turn it back to you, Heather. And I acknowledge and thank you for the tremendous job you have done for us here at OCFS.
Thank you, Commissioner. Thank you so much for those remarks. You have been such a longstanding ally for the Indian Child Welfare Act and for the needs of the Office of Native American Services, and we know we can look to you for support. For those of you who are not familiar with me, my name is Heather LaForme Maldonado, and I'm the Director of the Office of Native American Services. The Indian Child Welfare Act has been a piece of my everyday work since starting with OCFS. During this month of Native American Heritage, it's a time to celebrate culture, customs, and teachings of the Indigenous population. But we also use it as a time to use this month to bring the challenges that communities face to light, such as the challenge that is facing us right now. Today's program, we will hear from OCFS Attorney Craig Sunkis, State Regis Mohawk Nation Chief Judge Carrie Garrow, and OCFS Native American Services Program Assistant Veronica Treadwell. Each will provide important information on the Indian Child Welfare Act. So I want to thank you all for attending today's webinar and hope you will continue to or become an ally for the Indian Child Welfare Act. Now, please welcome Craig Sunkis.
Good afternoon, everybody. Before I begin, I'd like to thank you, Heather, and Commissioner Poole and Deputy Commissioner Gardia-Gundimu for having me for this presentation. It's extremely important, and I'm happy to be here to provide a little bit of background. So what I was asked to discuss were the legal requirements under ICWA, which I'm going to give a brief overview for, and then I'm going to talk about the Supreme Court case that's already been referenced, and again, give a brief overview. For those who are unfamiliar with this, ICWA is the Indian Child Welfare Act. It was passed in 1978 by Congress, and also portions of it were adopted by New York State. As Commissioner Poole stated, it is the gold standard for child welfare. And the goal behind it is to give Native American tribal peoples a chance to hear their own, have jurisdiction in child welfare cases where possible. So that's what I'm going to start with. The first sort of requirement is to provide exclusive Indian tribal jurisdiction over child welfare proceedings where Native American or tribal children reside on the reservation or Indian lands, except where in certain cases where it's vested by federal statute in state courts, and to authorize the transfer of some proceedings as involving Native American children who aren't or don't reside on on tribal lands from state courts to tribal courts. And again, I think what it's really important to remember, and what we're all going to see as I go through this, or I hope that we see as I go through this, is that the goal of ICWA is to provide Native American tribal children and families a chance to be involved in the child welfare proceedings. Let the Native American tribal jurisdiction fall with them where it's possible. The second right, or requirement, is it's called an establishment of a right of intervention. So in state court proceedings where there's a foster care or termination of parental right proceedings, there's a right for the Indian, for the Native American or tribal child or custodian or tribe to have a say in the matter. We want to make sure, the federal government wants to make sure, New York State wants to make sure that they have a right to be heard in these matters. The third requirement is the right for tribal courts to receive full faith and credit. This is a standard right for any court in the United States, whether it be state or federal, that these decisions made by these courts are given full faith and credit by the other courts. The next requirement is to require in any involuntary proceeding, think of a termination of parental rights is probably the best example. Many of those tend to be involuntary proceedings, where that there's actual or constructive notice when a Native American or tribal child is involved. And that notice is going to be provided to the Native American custodian, the tribe, or in the sense that we're not sure, it's going to be provided to the Secretary of the Interior so they can get the proper information. Again, the idea here is to make sure that the Native American culture and way of life is protected, and the way you do that is to provide that notice so they can be heard in court. The next is to provide a right to counsel for court-appointed counsel for any indigent parents and any removal, placement, or termination of parental rights. Again, indigency should never be a cause for someone not to have proper representation. And again, it's just important to make sure that that people have a right to be heard. The next requirement is the federal government established minimum federal evidentiary standards for procedures in state court proceedings involving foster care placement of Native American children or termination of parental rights. The federal government here wanted to make sure that Native American children were being treated fairly across all states, not just one state. They didn't want to vary, so they went in and they put forth minimum standards. In following that up, they also established federal standards governing foster care placements, pre-adoptive placements, adoptive placements of Native American or tribal children. Again, wanting to make sure twofold here, that all the states in the union followed a similar pattern, and to prescribe that these placement options are considered, and the first placement option is with the extended family. Then the next would be with a member of the tribe, and so forth and so on. But you can see the idea here behind ICWA is to, again, to keep the Native American child in the Native American tribe where possible, and in the culture. And what can you say other than that is absolutely one of the most important things. So they've also established, sorry, I actually jumped ahead of myself. They also established standards governing voluntary foster care. Yep, I've got that. Okay, yep, actually the last one, I didn't jump ahead, was they provided for a system of record keeping on the part of states when placing Native American or tribal children for adoption, and authorizing access to records by Native American children when they reach age 18 for the determination of their tribal affiliation and any related rights. And although it's not written, I'm sure also to protect their cultural heritage. Any adopted child would like to know where they come from. And I think that's as important, if not more important, for the adopted Native American, because there's a whole culture and a heritage that has to be protected. So those are the basic requirements, and this is again a high level sketch of these rights. I encourage you, if you're interested in this and you want to learn more about this, to visit the OCFS webpage, the Native American Services tab to be precise, and you'll find this information and much more on ICWA. The second part of the presentation that I would like to discuss rather briefly is the court case that the commissioner and Heather highlighted. It is the court case is Brackeen versus Hayland, and it centers around a challenge to the constitutionality of ICWA. It was brought by the states of Texas, Louisiana, Indiana, and some individual plaintiffs. Now, I'm not a constitutional scholar and by any means, but I think it's important to try to provide some context in the basics behind the case. And really what it boils down to are two questions. The first one is basically an equal protection argument. And the equal protection clause of the Constitution, which is the 14th Amendment, basically says that every law will treat persons equally and not discriminate on the basis of membership to a protected class, such as race. What the plaintiffs are challenging ICWA are arguing is that ICWA's placement preferences prioritize, tribal or Native family placements in violation of the Equal Protection Clause. The idea is here that the Native American or tribal placements are given a are given greater priority over non-native placements, which would be a violation of equal protection based on race. Is it a good argument? I don't think so, but it is what the plaintiffs have argued. The second argument is comes under a very technical part of the Constitution, and it's really an anti-commandeering argument. The 10th Amendment basically establishes the power that the federal government has and sort of what the states have. The federal government has whatever the Constitution grants it, and although that sounds narrow, it's been interpreted more broadly over the years. And the states have any other power that isn't named in the Constitution and isn't prohibited by the federal government. Traditionally, child welfare has always been a state right, not a federal right. So what the plaintiffs in the case are arguing is that ICWA wasn't within Congress's right to grant because it's a power and duty reserved to the states because it's a child welfare matter. And by passing ICWA, again, they have gone outside their constitutional power by implementing a child welfare placement program within the states. Is it a good argument? Again, in my opinion, not so much, but those are the basic arguments. Please understand that was a very oversimplification of the arguments. If you're interested in the arguments in any greater detail, I would highly recommend doing a web search. There will be a lot of decisions and articles written on all of this, and you can get a much greater understanding. If you really want to get into it, there are constitutional scholars, and you will see papers published by them. If you're interested, and it is an interesting legal argument, but unfortunately, we will end up waiting for the decision until about June. I believe that's when they're scheduled. The Supreme Court decisions often take a great deal of time to write. So that really concludes my part of the presentation. Again, I'd like to thank everyone for letting me come on and talk about this important issue, and I will turn it back over to Heather.
Thank you, Craig. Thank you so much for that analysis. And now we will turn it over to Judge Carrie Garrow.
Thank you. I'm going to try to share my screen, which sometimes is a challenge. Okay, Heather, can you see this?
Yes, we can.
All right. Well, thank you so much for having me here. It's an honor to be here, and thank you to Commissioner Poole for your continued support of ICWA and the Indian nations. And I was delighted to hear about your visit, and I want to extend an invitation when the snow breaks, like in June of next year. I hope you'll come visit us, even though it's a bit of a trek. But we'd love to have you out here, and we'll show you around, and so you get to experience some of the highlights of culture here in Akwesasne. So thank you, Heather. I don't have tons of time, but my task is to talk a little bit about why ICWA is important. And the way I like to do this is to share a little bit of the history of the relationship between New York State and the Indian nations. And the reason I do this, and I used to explain this when I was teaching law school at SU, is that when leaders from the tribal nations or our families, come into court, or you're having a meeting with tribal leaders, we bring our history into that meeting or into that court hearing with us. And I'm sure many of you are familiar with the ACEs study and historical trauma. And if you're not, I encourage you to ask Heather. She has wonderful resources on that. And so this is a little bit of our history and why we need the Indian Child Welfare Act. So historically, once New York State formed, and our nations were here long before New York, and I apologize for my voice, it's getting over a cold. New York started doing these investigations and studies into what to do with the Indian problem. What do we do with these little pockets of land where we're not really sure what to do with them, and the federal government seems to think the federal government has the relationship with them and the states shouldn't, and we want access to this land, and how do we assimilate them? And so one of the first investigations was in 1888. It's ended up in the Whipple report, and it's a fascinating read. The nice thing about New York State is it kept a lot of the historical records, and they didn't get destroyed in the fire in Albany. And it's a fascinating report, but it's over 100 pages. So I'll just give you a quick summary of it. But what they did was they went to all the different territories, the Indian territories here in the state, and they held these hearings, very biased hearings, only wanting to hear from certain people. And the focus was, how do we assimilate? And so this was one of the conclusions from the report after they went and visited all the different territories. And they noted that as long as the Indian nations are wards, right, their children, this will still be a problem. They need to be educated as men, not as Indians. And keep that in your mind about education. And they wanted the nations to be absorbed or assimilated into the American people. And then the Indian problem would be resolved. So one of the recommendations in the 1888 Whipple report was compulsory education, to educate the children, right? They thought, and that was a common tool across the United States. Let's educate the kids, and then they will be assimilated into American society and will get rid of the Indian problem. And so, eventually, in order to focus again on the children, there were boarding schools across the country to focus on educating our children. And in 1855, here in the state of New York, we're the only state that had a state-run Indian boarding school. It actually started out as a private boarding school, and it's out in the Seneca Nation territory out at Cattaraugus. And the individuals who started it actually allowed Seneca language and other languages to be spoken. But once the state took over in 1875, then that changed, and the focus was on assimilating the children. We weren't allowed to speak. There's some great books written about it. I will give these slides, the PowerPoint, to Heather. She can distribute it. I put a link in here to this great documentary, Unseen Tears. We don't have time to watch it today, but if you haven't seen it, I would encourage you to watch it. And survivors from the Thomas Indian Boarding School and some of their children talk about what it was like, and also what it's like to be parented by a person who grew up in a boarding school, and essentially didn't have parents because they were removed forcibly sometimes from their parents. They were told that their parents didn't want them anymore, and parents were told, you can't visit them. And unfortunately, sometimes abuse happened as well. And so that's part of our history. The Thomas Indian Boarding School actually was one of the longest running schools. It wasn't closed until 1957. And New York has never issued an apology because of that. And interestingly, once they began to move away from the boarding school, the state focused on then busing children into public schools, because the thought was, well, it's not really working, keeping the children secluded, even though they were removed from their families. They're not assimilating fast enough, but if we put them in the public schools with non-Indian children, they'll be more likely to assimilate. So children started then, Indian children started going more and more to the Indian public schools. So then in the 50s, and this is before the Thomas Indian boarding school was closed, the state was doing an investigation about whether or not, and it was lobbying Congress, United States Congress, to give New York State criminal jurisdiction, because there was some litigation that resulted in a court case that said, New York State, you don't have criminal jurisdiction on the territories, and New York didn't like that. And so they held all these hearings again. They were very biased. They wouldn't allow the Indian people who came in and wanted to testify and talk about the treaties. And the attorney there would just tell them, "Oh, we're not actually here to talk about the treaties." And so the Joint Legislative Committee, who was holding a lot of these meetings and actually continued to issue reports for several years, it even acknowledged why, again, trying to obtain jurisdiction in the Indian territories, because it wasn't enough that, they're trying to assimilate the children, but they're also, and the reason that they're trying to assimilate children is that they want the lands, right? Because the Indian nations are sovereign, they're not subject to taxes, they can't be bought and sold by non-Indians. And so this is just one of the quotes from one of the reports. And it just makes me shake my head. They, talks about, well, they say, contrary to many assertions to that effect, there's no apparent prejudice. But then it goes on to say, it's greatly hoped that the Indians will reach the point of desiring to hold their lands in severalty, as do Western tribes, to abandon the present restrictions against ownership by non-Indians, because they wanted to be able to tax the land and to be able to get around our sovereignty. And so there's this focus on trying to assimilate the Indian nations through children by obtaining jurisdiction over the Indian nations. So, and this is just a link when you have the slides. I have a much longer article about, give some more of the history, which we don't have time to go into today. But eventually, Congress holds some hearings about what's happening in Indian country, including New York, about to Indian children, and the rates of that Indian children are being removed, because we moved out of mostly out of the Indian boarding school, but now the social services agencies in the states are removing Indian children at a higher rate than non-Indian children. And so Congress holds hearings, and it's fascinating to go and read the hundreds and hundreds of pages of the testimony. So 25 to 35%, and this is in the record of the hearings, of all Indian children were separated from families, and they were going into adoptive families, they were going into foster care or institutions, and they went through some of the various states to see, what the rates of removal was. So Minnesota at the time, 1 in 8 of Indian children were in adoptive homes. And during 1971 to 1972, 1 in 4 infants was placed up for adoption. And in New York, and also keep in mind, 90% of those were in non-Indian homes, right? So we went from getting, taking the kids and putting them in the boarding school, and now we're taking the kids and we're placing them into non-Indian homes. So even in New York, the statistics were 1 out of 74 Indian children versus 1 out of 226 white children were placed in foster care, and 96% at that time were placed in non-Indian foster care. And so the adoption placement was also much higher. And so Congress realized that this is a problem, because what happens to a nation when you start to lose your kids? You dwindle, right? Because now they don't grow up into successful adults to be, to run the schools and run the government and run the hospitals and the banks and the restaurants, and also to maintain our culture and our language. And already in the boarding schools, we were forced to not speak our languages. So we're already dealing with that trauma. And now we're being adopted out and removed. This is just a quote from one of the chiefs from Mississippi Band of Choctaw, and just during the testimony and acknowledging that they're being removed for no reason other than not understanding our culture, how we might parent differently, or how an extended family might be involved, or how we might move depending on whether it's fishing season or ricing season or hunting season. And when you listen to the record, you hear all these parents testify about how their kids were just simply removed, no due process, never even saw a courtroom. And I was doing some work up in Maine with some of the tribes up there, and talking to their ICWA worker, and this was after ICWA, who still talked about how the when the kids were out of school, of course this was not during the winter, and got out of school after school and were biking around, the social workers would go around and pick them up. And so it was a very, parents were very fearful about leaving their children unattended, because there was this bias and mistrust of that Indian people, you're poor, you don't know how to parent according to the American or white standard. So Congress eventually enacted ICWA in 1978, and here are some of the findings. And I won't talk about the statute. That was great that we got an overview about it, but it's important to keep in mind the findings, right? So this is the reason we have ICWA. And Congress noted that there's nothing more vital than our resources, than our children. They acknowledged the high percentage of Indian families that were being broken up by non-tribal and public and private agencies, and that the states failed to recognize the tribal relations between our people. And interestingly, I was just doing some other research on leadership, and came across some research talking about reminding us the importance of maintaining your citizenship to a nation. Something that is integral to maintaining that citizenship is being in the space, right, where the language and the culture and being a part of that, and how important that is. And so then Congress declared, as part of the policy behind ICWA, is to protect the best interests of Indian children, right? And to promote the stability and security of Indian tribes and families. And so ICWA then places these minimal federal standards for removal and placement, which were talked about previously. And so in order to stop this high rate of removal, the gold standard, which now many, as Commissioner Poole noted, many experts in child welfare talk about the gold standard, right? Active efforts. And it's interesting now to see all this research about removal of children and what happens to them, whether they're native or non-native, and how difficult that can be, and how it's been amazing to watch how many states across the country are doing reform to keep children in the home and put supports in place, which is what ICWA does, right? You can do all these active efforts to keep children in the family or return them as quickly as possible, to prevent more trauma, and also acknowledging that the tribe has an interest in these children and having healthy children and families in order to maintain our sovereignty. And so we know, as I just talked about, we know what happens when we remove a child from a home. It's very traumatic. And I've talked with some of our tribal social workers, and they talk about how, because they know how traumatic, because we have this history, and they when they try to go in, they try to make it very non-traumatic, and just they do a lot of placements with families, and we're just going to grandma's, and you're going to stay with grandma, you're going to stay with your aunt. following those placements, right? Placing with someone in the family or someone within the tribe who may not be a relative but knows the family, or at least keeping them here, surrounded by the support of their extended family and of the tribe. And it can be to help lessen some of that trauma while their parents are healing from whatever trauma they've endured. And so I get this question a lot, like, it's 2022, that was the 70s. Do we really still need the Indian Child Welfare Act? Well, the answer is yes. And if you look at a lot what's going in some of the other states, like there was a class action out in South Dakota, and you hear about some of the rates that children are still being removed. The answer is yes. Unfortunately, we still need the Indian Child Welfare Act. This was a study I came across. Now, this was an urban study looking at American Indian, Alaska Native children, that 1% were investigated and 3% are placed in out of home care. So it's a high rate of removal. And that American Indian and Alaska Native children were almost 2 times more likely to be removed, despite caregivers of white children were slightly more likely to have substance use disorders. But for whatever reason, our children were being removed at a higher rate. And again, unfortunately, I think it's that not understanding or bias or not putting the needed supports in place to help those families and care for them, so they don't have to be removed. And I've been fortunate enough, I've spoken with Heather several times, and with Veronica. We've been on many different panels, and I've had training, been fortunate to do some trainings across the state. And I talked to some great people who do some great ICWA work. I talk with sometimes it's judges, I'll be honest, who, maybe we could work on our understanding of ICWA just a little bit more. And so it's a constant need. It's such an important resource to us. These are our children. For me, 1978 when the 1974 was when the hearings were happened, 1978 was when ICWA legislation was passed. For me, I'm gonna date myself here, that's actually not that long ago. I was a child back then. I know I can't even count the number of friends that I know from different nations who have family members who either went to the Indian boarding schools or were removed, and then their families are dealing with that trauma, which now here in 2022, our families are still recovering from this trauma. So so we're still might be dealing with issues trying to heal that trauma. And some days I think it's just a miracle that for whatever reason I managed to not be one of those kids who was removed for whatever reasons. Because it could have been me. And so one of my focuses is, and I know I have to wrap up, but is I run a family treatment court, and our focus is to work as hard as we can to help our parents get their children back or not have their children removed, and to deal not just with substance use disorders, but to help heal the trauma, which is incredibly hard, and it takes a lot of work, and it can be a lengthy process, and that's why we need our partners in the state and people to stand up and defend ICWA and practice ICWA in order to continue to keep our help us in our work with keeping our children safe and working on keeping helping our families be healthy. And so with that, I'm going to toss it back to Heather. And I'm going to stop sharing my screen, I hope.
Thank you, Judge, so much. Love the presentation. It really hit home why ICWA is important. why Congress had decided to, to enact ICWA. So thank you for all of that information. I'm now going to hand it over to Veronica. Let's see. There we go. Thank you. Veronica, you are on.
Unmute myself. Good afternoon. Thank you, Commissioner Poole, Craig, Judge Garrow, and Heather, of course, for all that you have already presented. I have had the task of talking about something positive when it comes to ICWA. I was asked to think about a case that had pretty good results that could have turned a different way. Let me just read a little bit of what I wrote. This matter was filed by a local DSS alleging that the respondent's mother had a prior finding of neglect with respect to an older child who was not tribal affiliated. The respondent mother, who was non-tribal affiliated, and father, who did have tribal affiliation in 2 different tribal nations, appeared before the family court on a petition. The mother's attorney requested that the proceedings be transferred to a local tribal court that the father was affiliated with. And a representative from the tribe who was present pursuant to the Indian Child Welfare Act of 1978 was also in agreement, as the circumstances associated in her prior neglect finding were no longer present. The mother had completed all programs, had gotten married, and was living a pretty productive life when she was in the process of giving birth to another child. The opposition came in by an attorney for the child, who basically said that he was not in agreement, that the child would still be in danger, and was not allowing the child to be returned to the family once it was born. They were looking at a removal. This was in advance. With that being said, Social Service Law 39.6 provides that any state court child custody proceeding involving the foster care placement of or termination of parental rights of an Indian child not domiciled or residing within the reservation of the Indian child's tribe, the court, in absence of good cause to the contrary, shall transfer such proceedings to the jurisdiction to the tribe, absent objection of either parent. And at this point, neither parent objected. They were in agreement upon the petition of either parent or Indian custodian. The tribe, the parents, everybody was in agreement that this case should be transferred to the tribal court to oversee. The positive point was the family court granted the nation's application and transferred jurisdiction over the proceeding to the tribal nation, with the understanding that ICWA's purpose is to protect the best interest of the Indian child and to promote stability and security of Indian tribes and their families by establishment of the minimum federal standards for the removal of Indian children from their families and the placement of such children in foster or adoptive homes, which reflect the unique value of Indian culture. ICWA states that an Indian tribe shall have jurisdiction exclusive to any state over any child custody proceedings involving an Indian child. In this case, the law guardian for the child filed suit against the tribe and to have the child removed. In any other situation or circumstances where if we, the tribal nations, would not have been involved, this child would have definitely been removed due to the mother's prior neglect findings, because that's just how the system works. Again, the attorney for the child appealed. However, the ruling to transfer jurisdiction to the tribe remained and was granted, but this went up almost to the Supreme Court. It was a very difficult case because the law guardian truly did not believe that the tribal nation should take jurisdiction of the case. And just to give a little bit of an update on this. The family is strong, remains intact. The child is doing well. The family now owns a home. They run a business. They have had another child. The child is in sports. He's doing really well. The family remains intact. And all of this is part of what the spirit of ICWA calls for. The family initially had some issues. The tribe came together. They supported them. They gave them what they needed. And now we're talking about 8 years later, and they are not a part of the system. They are productive parts of society and able to remain in the tribal customs and traditions and be able to live according to what the spirit of ICWA applies. So that's just, I mean, there's a lot of history behind it, why we do what we do, but this is just a snapshot of a case that could have gone really wrong, because the first child the mother lost was put up for adoption. Her rights were terminated and it was put up for adoption. However, the positive thing was the parents who wind up adopting understood the situation, saw the progress the family was making, and has now become an extended part of this family. They spend holidays together. They bring both children together. Now there's 3 children. So that's, for me, it was a win. So that's my part in basically the golden standard of making sure that we step in and give the tribes every opportunity to support and take care of their families to be able to remain and stay together. I thank you for this time. That's my piece. Back to Heather.
Great. Thank you so much, Veronica, for that
You're welcome.
snapshot.
You're welcome.
It's very important, and again, it's very important to see how the case could have went another way and how the tribal nation was able to step in because of ICWA and keep this family together and connected to their nation. And now we will turn it over to Lisa Gardy Ubendigo for closing remarks.
Good afternoon. Can you hear me?
Yes.
So thank you so very much to everyone, Commissioner Poole, to Judge Garrow, to Craig Sunks and Veronica Treadwell for your presentations today. One of the things that I wanted to lift up is the importance of our understanding our history, to understand how we got here. You know, as Judge Garrow said, 40 years is not that long to address a harm. And when we look at what brought us to ICWA, the reason that the congressional hearings were had is because there was recognition about the high number of children being removed from tribal nations. This was by design and created lasting harm. And this was an effort to address that harm. For us to stand here today without knowing the history and knowing the why, and we've been talking within OCFS often about our why we do this work, it may seem, why do we need this? And when you listen to and I encourage all of you to go back and listen to the Supreme Court argument. It's at once overwhelming, daunting, and really sad because many of the justices did not take the time to do their homework and don't even understand why ICWA is important. It's about sovereignty. It's about addressing a harm. It's about standing up as a nation and saying, we did something really bad. We based a decision to break apart families, to remove children from their heritage, from all they know, for what? To do what? To address what? So if you don't understand your history, you don't understand the why, you don't understand the decisions that have been made to bring us to the place that we're at, it becomes confusing. But if you take the time to look, to understand, to deepen your understanding, then you know that the importance of ICWA is as important as any of the work that we do. We have to do everything that we can to make sure that we as a system do not further the harm that has been created, that we truly are, as we want to be, trauma informed. And we are operating in a way that says, if a child must be removed, first and foremost, the placement is with relatives. It is with kin first and foremost. And we in New York have a broad definition of kin. So for us, it is a no-brainer. ICWA is important, and it must be upheld, and it must be maintained. I appreciate all that everyone has done today and the work that we continue to do. And everyone knows I love a podcast. So in addition to listening to the Supreme Court hearing, I encourage you all to go to wherever you get your podcasts and listen to This Land. It's an amazing podcast, and it talks deeply about the importance of ICWA, the pain and how we got here, and is a call to action for us all to do more, to do better. We know more, and we can do better, and we should. So thank you for spending your time, for joining us for this wonderful presentation. And I open for questions. I think we have a few moments. If anybody has any questions, I don't know if there's anything in the chat or if we want to take yourselves off mute.
I don't see anything in the chat as of yet. So we are starting to get some comments coming in. From Karen, Lisa's comment makes me think of those who cannot learn from history are doomed to repeat it. Catherine says there's lots to process and take in. Really informative. Heather, thank you. This is from Heather. Heather, thank you, presenters. This is so educational. There are so many heartbreaking stories. So I appreciate the excellent positive story from Veronica. Question here, is there any effort to create a New York State law to replace ICWA if necessary? Lisa, you want to answer that one?
Craig, do you want to answer? We are. Go ahead, Craig.
Sure. I don't know the answer. I think it would be something that we have to wait and see what the court decision is. And then I think based off of that, we would have to see what provisions, some certain provisions are already in New York State law. So there would probably not be a new law would be my guess. It would probably be more along the lines of an amending of the existing New York State statute. That would be my guess.
And we are advocating strongly to make sure that we protect ICWA within the state of New York. So and I think, as we mentioned, also the New York State Attorney General's office joined with an amicus brief, also advocating for upholding ICWA. So this is, you have support all across, up and down the administration to support ICWA here in New York.
Thank you. Just one more comment that says, thank you so much. It is so daunting that this is happening. Absolutely. I don't see anything else coming in. Jeffrey says, thank you for the information. Liani says, very informative as the information comes up in OCFS race equity and cultural competency. The trainers also recommend the OCFS ICWA training in HSLC. Please feel free to reach out to myself or Veronica. We do in-person ICWA trainings as well. Unfortunately, I will be out, not fortunately, I will be out on maternity leave until June, but Veronica will be available. We can do them Zoom or in person for your bureau or your units. Or if you just have questions, please feel free to reach out to myself or Veronica. You can find us in Global. If there aren't any more, Liani says, congrats, Heather. We'll definitely reach out to Veronica. Thanks. So if there aren't any more comments or questions, again, I thank everybody for taking the time out of their day to join us and listening to everybody who presented today, Veronica, Craig, Carrie, Lisa, on the importance of ICWA. And again, I encourage you to, if you're not already an ally, to become an ally. Please put on your social media, protect ICWA, protect tribal sovereignty, because it's so much more than just ICWA and what this means for the tribal sovereignty for the over 570 tribes within the United States. So, thank you.